the various divisions that have been working around the clock to ensure that we complete this review of our Cybercrimes Act. All right. My recollection of our last meeting is that we had finished going through all the stakeholder comments, and the ministry's team was to have a set of meetings.
Chair?
Yes.
I'm sorry to butt in, but the next agenda item would be prayer.
Okay. Let me ask Senator Rodriguez to lead us in a word of prayer.
Since we're not hearing from our prayer, I will lead in prayer.
No problem.
Most righteous and heavenly Father, we're back at this issue again. We're looking at a very important piece of legislation. We invite your presence, we invite your guidance, we even invite your thought, because you know we cannot do this without you. And so these we ask in your merciful name. Amen.
Thank you, Senator Gale. All right, so any other apologies or absence? Apologies for absence?
Sure, can I apologize for an intended absence at about 3:30, sir?
You represent Senator Gale.
Yes, but I have to leave.
Don't apologize yet. Don't apologize yet. We might be very efficient.
Okay.
There are no apologies, Chair.
Other than Minister Vaz. Okay. All right, let me see our next agenda item. I think that's the one I had started with, just to welcome everybody. So I won't go over the opening remarks, and we will get straight into the reading and confirmation of the minutes. Now we have two sets of minutes. We had deferred July 27th, and we have from our last meeting, which was October 12th, 2022. Now, seeing that Minister Vaz had chaired those meetings, I don't know if we believe that we should also defer these reading and confirming these minutes until Minister Vaz is back and assumes the chair, or if it's the will of the committee for us to go through. Assumes the chair, or if it's the will of the committee for us to go through. Yes, Senator.
One of those meetings, this one in July, was not chaired by Minister Vaz, just chaired by Golding Campbell.
Okay.
So I would suggest. Okay.
Sorry, I never got the suggestion. The suggestion was to defer.
No, Mr. Chairman, I'm suggesting we go ahead, even with the one from July, but I would support going ahead with both. The one in July was chaired by Senator Golding Campbell, who's actually here today. So.
Okay. Okay. All right, so the minutes have been circulated. Let me. The minutes have been circulated. Let me. Okay, so I'll start with the minutes from October 12th. So I was a part of that meeting. Any corrections? Page 1, page 2, page 3, page 4, page 5, page 6, in the corrections, page 7, page 8, page 9, page 10, page 11, page 12, page 13, and page 14. If there are no corrections, could somebody confirm the minutes of October 12th?
I got hit off a while ago.
I think you're having some technical difficulties, Senator Rodriguez. Unless it's on my side.
I can
Confirmation.
confirm.
Chairman, are you hearing me now?
I'm hearing you. Confirm. No, we're having some, I think you're having some difficulties, Senator Rodriguez. Yeah. Confirmed by Cavan. And once I'm able to have second, I was at that meeting. So confirm and seconded. Let me try to pull up the meeting now from July 27. All right, we're going to go through the meeting of July 27, the minutes. Any corrections, page 1, page 2, page 3, page 4, page 5, page 6, page 7, page 8, corrections to page 9, page 10, page 11, page 12, page 13. If there are no corrections, could somebody confirm the minutes of July 27th? Is that you again, Member Gail?
Yes, sir. Confirming.
Seconded by Member Golden. Member Golden, are you seconding the minutes? I can't do this one, I wasn't there. Or somebody else, Member Robinson?
Yeah, I can second the minutes. Yeah.
All right, excellent. So we have confirmed both sets of minutes that were outstanding. So we can now move to the next agenda item, which is really matters arising from the minutes. Unless there is something in particular, based on where we were at our last meeting, the Ministry of Science, Energy and Technology team were to go out and do some further research on some of the provisions that we have been through, and also conduct some meetings with specific entities such as Ministry of National Security and other entities like SIMTI to seek clarifications on other matters. I know that the team has worked very hard and circulated a document earlier today to the committee in relation to their further research on the area. So what I propose, once the committee is fine with that, is that we go directly into those areas that we had already gone through when we had asked for either clarifications or additional information, and we had directed the team to set about getting that information and to see if we could come to firm recommendations. What I would suggest is that we go directly into that and have a presentation from the Ministry of Science, Energy and Technology team, unless there are any pressing matters arising from the minutes. If not, I would think we could go directly into that presentation. Okay with the committee? Take the silence as a yes. Not sure who is going to lead us through that. Newton Smith, is that you? Or Joaquin?
It will be CTD. Good afternoon, Chairman and members. It will be CTD Murray this afternoon.
Okay, wonderful. CTD Murray?
Afternoon, Chair. Good afternoon, members, colleagues.
Right.
As you indicated, Minister, where you left off is where we're picking up to just tidy up or recommit to the members some outstanding matters. We want to apologize for the lateness of the submissions, but we tried to ensure that we had all as many of the comments as we could in respect of each matter, so that could have a fulsome discussion on as many items as possible. We'll see, however, that there are one or two comments that are still outstanding, and we'll indicate to you exactly where that is. But we believe we have sufficient to be able to take the members through and hopefully be in a position to maybe have one more meeting, Minister, but that would be it if once the committee is satisfied. So the matrix dated November 23rd, 2022 is what is before the committee. And the first matter to be addressed is the matter in respect of the use of the term mental injury vis-a-vis psychological injury. The Legal Reform Department did extensive research on this particular matter, and I am going to yield to from the Legal Reform Department to take the committee members through. I am suggesting, with your indulgence, Chair and committee members, that Section 2 as well as Section 9 be dealt with together because the issues are similar, and it would probably it would be better in better order for them to flow together as opposed to separately, although they're separately stated on the matrix. And with that, Chair, I will yield to Erica, I believe Erica Simon, who's from the Legal Reform Department.
Good afternoon, members. So in looking at sections 2 and 9, the question came up as to whether or not we should use the term, maybe I should backtrack a bit. The recommendation was made with regards to section 2 that we include either the term psychological injury or mental injury as a head of damage that can be contemplated in assessing aggravated damages under the Cybercrimes Act. So we had done some research and had presented what we had found, but further clarification was required. So what I would say is that what we have found with regards to mental injury is that in civil litigation, that it's the courts assess that as being a recognized psychiatric illness. It's not a term that we have seen used in legislation in our jurisdiction. Well, it is used, but not defined. And in the jurisdiction where we found a definition, it's defined as being clinically significant behavioral, cognitive, or psychological function. So based on the case law that we found for how mental injury is looked at and how mental harm is looked at, mental injury, sorry, this one. Right, mental injury from the case law was seen as a disturbance of the mind that is serious and prolonged and rises above the ordinary annoyances, anxieties, and fears that come with living in a civil society and need not be proved by medical evidence. Where mental harm was used, we found that the interpretation was that it was a recognized psychiatric illness. But where psychological injury or harm is considered, that term is considered as an aggravating factor in determining the appropriate custodial sentence. And usually where considered, medical evidence isn't required, and the court can make inferences based on the evidence that they've received, based on a social inquiry report or statements from the victim. A medical diagnosis isn't needed, but if the court feels so, then one could be obtained. So based on those different considerations and the apparent, the fact that it seems that the courts tend to view mental injury and mental harm as being a recognized psychiatric illness, which is not what we think would be likely to result from the kind of harm that would result from somebody being subjected to a cybercrime. We think it would be more appropriate to use psychological injury as opposed to mental injury in Section 2. As for Section 9, I think the members will remember that we had proposed a redraft of that section, and the redraft was to take care of certain issues with the section, such as the fact that obscene wasn't defined and what is a menace wasn't defined, and it was difficult sometimes for the courts to figure out whether or not a particular case before them fell within those parameters. And so we had proposed a redraft that would have removed those terms and focused more on the fact that the person has suffered a kind of harm because of the cybercrime. And in that revised section, we had proposed a definition for harm, which was a physical or psychological injury. And again, the issue came up as to whether or not it would not be more appropriate for mental injury to be used there. For the same reason as we articulated with regards to Section 2, we think that it would be more appropriate, more within the scheme of this act, to use psychological injury. The only caution we would add is that if we include it as an element of the offense, then we would not recommend that it be considered as an aggravating feature for the purposes of Section 9, not for the rest of the offenses under the act, but just Section 9, as it would already have been an element of the offense. And I think that about sums up what we have found and our position on the issues, unless there are any questions.
Chairman?
Yeah, so I think in sections 2 and 9, Dr. Longmore, stands up.
Yes, thank you. Thank you for that review and input. I had raised the concern, and I think the concern still exists. The truth of the matter is, and I mean, I understood that I am a professional in this field, so I'm not sure what references that you pull that information from. My concern came, and it still remains, that we are limiting the level of damage, and you yourself indicated that it is kind of anticipated that the level of damage would be, if I may say, merely psychological. The term mental encompasses the psychological. The psychological does not necessarily encompass all of the possible mental components that could happen. And so as we see where we're getting more and more enlightened with respect to mental health issues and the consequences of actions that are sometimes not as fulsomely appreciated in the damage that can occur, I would suggest that we seek to put as broad a coverage as possible when it comes on to the possible damage that can occur from to someone who is exposed to this risk in this space. I don't see what would be the harm in doing so. I don't see why we should not be as encompassing and as thorough as possible. And so I continue my advocacy for it to be mental damage in both clauses versus psychological. Thank you.
Well, thank you, Senator Longmore. Let me just ask, before you respond, let me just ask, because I wanted to see if my takeaway from what legal reform had shared was correct. Is it that you're saying that from the case law that you've seen, when the term mental is used, it is given a more narrow interpretation?
Fairly narrow. It's usually seen as a recognized psychiatric illness. And whilst we appreciate the concern, and I share the concern that you want to use the broadest term possible, the risk we think in using that term is because of how the term has been interpreted thus far. You may find that a person has suffered some kind of psychological or mental injury, but it's not a recognized psychiatric illness. So there's no, the person isn't convicted of the.
So the problem, Dr. Longmore, Senator, sorry, seems to be that the law has interpreted mental to be defined mental illness, which would not capture the sort of psychological harm that the broadness that the term really represents. The law hasn't defined it in that way. So it appears to me, trying to use that terminology may defeat the purpose that you're trying to get legally.
And Chairman, that is exactly the point. That is exactly the problem. If I were to break it down this way, most persons have a difficulty understand what is the difference between a psychologist and a psychiatrist. A psychologist deals with a certain aspect of mental health issues. To be a psychologist, you have to be trained in psychotherapy. A psychiatrist deals with the full range of mental health issues, including psychological issues. To be a psychiatrist, you have to be trained in psychology and then some.
Yeah.
And that is exactly the issue. And this is one of the reasons why I have in many forums and our advocacy for an update and a reform of the Mental Health Act is so critical, because it impacts on so many pieces of our legislation. So that is why I'm saying, for efficiency and effectiveness, especially in an area that is as technologically and time sensitive as cybercrimes, I would suggest that we provide the broadest possible basis for that coverage. And I repeat that mental, psychological is limited to a particular scope of mental health. Mental health encompasses it all. So, I understand the legal limitations and the lack of clarity, but I hopefully the understanding will come with appreciation for what I indicated in terms of the difference even between a psychologist and a psychiatrist.
Yeah. All right. The legal reform wants to say something else, and then I say Senator Campbell.
Sure.
I was just going to add then that what could be done if that term is used would be to define it. But the challenge we had was finding a definition that we could recommend. And what we would have suggested would be to do wider consultations amongst persons, professionals who have that kind of knowledge, who would be able to define that term. That's not something that we would be able to do as legal reform based on the research that we have found. We haven't seen what definition we could propose, but that would be a solution to using that term. So if you use the term, rather than have it to be narrowly construed in the way it has been so far, to avoid that, you would have to define it. The question would be then, how should it be defined?
Senator Campbell Rodriguez.
Thank you, Mr. Chairman. I'm just trying to get my camera on. Yes, I just wanted to say that I tend to want to agree with Dr. Longmore because she's a professional in that field. And if a matter is brought to the court, this is a question really to LRD. If a matter is brought to court and you put a psychiatrist on the stand, would their interpretation of the difference between psychological injury and mental injury differentiate how they would respond? Because if the answer to that question is yes, and I guess maybe that's for Dr. Longmore to answer. If the answer to that question is yes, then we have to use the term in the legislation that would relate to the professionals in that field. Because I'm not in that field, so I really don't understand the semantics between either terms. I use them on a layman term interchangeably. But if it is that if a matter were brought and a psychiatrist on the stand would respond based on a definition, we have to go with that, or we lose the teeth of the substance of what we're trying to achieve here. So I don't know if Mr. Chairman, if you'd allow Dr. Longmore to answer that question, so I know, because that would help me.
Yeah, we can ask Dr. Longmore to answer, and then maybe legal reform.
Okay, so thank you, Chairman. Okay, thank you for that, Senator Campbell Rodriguez. So without getting too detailed and not to take up too much time, let us say someone got traumatized to the point of having a loss of memory, for argument's sake, or enter what we call a fugue state, or go into a psychotic state. That is a field, that is a part of mental health that a psychologist does not cover. That is, they will analyze it, they will do a diagnostic around it. However, for treatment and intervention, they may refer or have to refer to a psychiatrist, because once there is a loss of touch with reality in the patient, in the client, it is no longer, or it is beyond the purview of a psychological intervention and requires a psychiatric intervention. Mental covers all of the above. So if you have a child who is traumatized to the point where they are now hearing the voice of the person who is tormenting them through the cyber camera that has been hooked up or illegally turned on, that psychologist who is given that assessment will have to then make a referral, if the person is having that type of loss of touch with reality, to a psychiatrist. It is all mental issues, not necessarily only psychological. I don't know if that explains the difference.
So I think for me, well, Senator, Senator Cam Rodriguez.
Thank you, Mr. Chairman. So that explanation clarified a little bit for me. And then I would have to lean towards what Dr. Longmore is saying from that standpoint, because if mental is more, so that's just my opinion based on that answer.
So the challenge, I think we're still as a committee faced with the challenge, and the challenge is this. Clearly, as Dr. Longmore has outlined from a very professional standpoint, mental connotes a much broader sphere of damage and harm that can be caused by these offenses, which is really what we're focused on, trying to ensure that where an offense of this nature is committed, that we are taking into account not just psychological harm, but also mental harm, which I think Dr. Longmore did a great job of showing us the difference in that explanation. The challenge that our technical legal people are saying is that the courts have not historically interpreted it in that way. So if we were to just use mental, we may run the risk, while having the best intentions, we may run the risk of actually narrowing the interpretation of the court to treat with just mental illness and to disregard psychological harm. So what legal reform is saying is that the only probably way out could be to try and come up with a definition. The only challenge I have, and I would be guided by legal reform, is whether this act is really the place to, I'm going to use this term, Dr. Longmore, stay with me. It's not really a redefinition. It is what it is. But if this act is really the place to define mental in its broadest sense, or whether really we would have to do fundamental changes to the Mental Health Act before trying to use this act to achieve that purpose.
Okay, so Chair, if I may also expand the thought. If the difficulty is that the precedence is set of recognition being on a psychological realm, any mental effect is psychological, or any psychological effect is covered by mental.
So let me just, not to stop you, but my understanding, Dr. Longmore, is that when the court say the term mental, they look for mental illness. So if somebody has a psychological harm that does not amount to a defined mental illness, then
yeah, but that's incongruent. That's what I'm trying to let you understand, that you cannot have a psychological harm without it being a mental illness.
Okay.
It cannot. Once you have psychological effect, it is a mental illness. It's just that we are somewhat programmed to think that mental illness is the loss of touch with reality mental illness. But someone who is anxious, someone who is depressed, is also mentally affected, but they're not necessarily in a state of loss of touch with reality.
No, so all right. So probably I should put it differently based on my understanding. If I start to get anxious because I have been subjected to somebody using the internet to spread all sorts of falsehoods, and I start to get anxious, would that fall in a defined mental illness?
If that anxiety is starting to affect your social and or occupational functioning, if there's a consequence, if it is starting, that is the essential definition. If it is starting to affect your normal activities and the engagement of such. So there is a clear definition. Whilst mental illnesses are on a spectrum from mild to severe, there is a clear distinction as to when it becomes diagnosable. The fact is that if there is any psychological harm, it would be a mental illness. There would be a definition for it within the scope of it being mentally affected.
Senator Golding, sorry, Senator Longmore.
Thank you, Chair. I just the point I really just wanted to make, because I'm not so sure that what we're arguing is really at issue. The fact of the matter is, and Senator Longmore can correct me if I am wrong, but a recognized psychiatric illness, while there is not a specific definition for that, isn't that a moving target? I mean, it at the end of the day, and over time, different conditions become recognized psychiatric illnesses. Is that not the case? And so I'm not so sure that we're at a disadvantage as is, given the court's treatment of the matter.
So, well, to take us back, because what we really need a decision on, what again, my understanding, and definitely legal reform can step in. My understanding is that legal reform is saying, based on their research, the court takes a very limited interpretation of the term mental, and as such, they're suggesting that we use the term psychological. Dr. Longmore is saying mental includes psychological harm, and as such, even though the court has taken that view over the years, that we should proceed with a terminology that gives us the broadest spectrum. The challenge that legal reform, I take it, has, is that if you put in a terminology, definitely their view without definition, then we're going to run the risk of the court following the precedents that has been set, and we're not going to achieve the purpose that we're trying to get done. Legal reform, it would be good to tell me if I'm off.
Chair, yes, that's in some is what we are saying. If
Chair,
we
did I
had
also, I'm so sorry, did I also understand legal reform to be saying that they wouldn't want to proffer a definition of the term? Did you say that earlier?
Yes, that was correct. Based on our research, we were unable to find an appropriate example that we could recommend, and I do not think, based on the knowledge that I have of the area, that I could suggest one outside of finding one in research, which we have not.
Chairman, if I may, I know we don't need to belabor the point. And this is not the end of this process. And perhaps my advocacy for the appreciation of the importance of mental health issues is probably causing me to be a little bit more fervent about my pursuit here. So let us, I mean, the process, as we indicated, is not finished. I agree that the overarching issue, the real issue, is the need for the update of the Mental Health Act. There's absolutely no question there. But there also needs to be the appreciation that mental health issues and illness is not just the madman out on the street. And we need to bring this into our legislation. It is a stark reminder of the lack that exists at that level. And so I am willing to allow the process to proceed, but I mean, there are other forums in which I can raise it and also seek to bring this enlightenment.
Agreed.
Thank you,
Chairman, might I suggest, therefore, that having interrogated this particular matter, then when we do the report would emphasize the need to, to go further by one. Mrs. Simon had indicated whether or not she could, or her team could speak to experts that may very well come up with a solution in terms of a definition, but also the report would suggest that all the areas that require changing to create the need of impact will be done. And it would have come out of the discussions taking place in this particular committee.
Yeah, so two things, and I'll say, I think one, we have made movement. I think that is really a testament to the advocacy of Senator Longmore. So one, what I hear the committee to be saying is that we will agree on the approach suggested, recommended by the Legal Reform Department in terms of the terminology that will be used, but we will include in our report what we see are the deficiencies, and more importantly, strong recommendations regarding how we treat with definitions of mental and mental health. And I think a very strong call for the reform of our Mental Health Act.
Thank you, Chair. Thank you.
Yeah. Okay, so CTD, we could move to the next matter.
Yes. Yes, Chairman. So the next matter for consideration for the committee had asked us to look back at the use of the word key in the definition of the word key. Members may recall, so based on our research, and we've outlined the definition there in the matrix, but members may also recall that at the time of the discussion, there were certain statements that would have been made with respect to whether or not this is a drafting anomaly. And what we have seen, Chair and committee members, is that there are no legislation that we've come across that actually use the word, well, define the word keys. So we had no example to draw from in that regard. And so what we have applied and what we've come back to the committee to say basically is that the purpose of the definition of the word key is to identify the methods by which access to data or output can be facilitated or data can be placed in intelligible form. Note that it's not a drafting anomaly to have a word that is being defined reflected in the definition of the said word. And in this particular case, what the definition of key is seeking to address is the ordinary meaning of the word, while enlarging the concept of the word so as to include other methods of access or putting data into intelligible form. The committee is reminded that the CPC, when she spoke on this matter at the sitting at which this matter was deliberated, opined that based on the fact that this is a Cybercrimes Act, which is intended to be technologically neutral, it was not desirable to go in depth with a specific definition of the use of the word key, or to define key in the use of the word key. And bearing in mind also that the ordinary industry meaning of the word would be applied if the term came up for interpretation in the courts. And that the definition of key is best left for interpretation as in the industry. And so committee members, that is what we would like to put before you in respect of this particular matter.
I think that's fairly clear. Any questions from the committee? If not, we would accept the research and recommendation of the technical team, and we would move to the next matter. Next matter, CTD.
So the next matter, Chairman, is on page 10 of the matrix, and it treats with a recommendation from the private sector organization of Jamaica that a framework be developed that provides for the recognition of ethical hackers in the legislation. At the time this matter was deliberated, the ministry had indicated that it doesn't support the recommendation.
Sorry, hi. Question, can you just clarify for me, because you're going back, you're referring to the matrix that we have in front of us now. On what page are
sorry,
you?
so this is the, and sorry, Senator, let me help. This document was sent out this morning, right? Hopefully everybody saw it. So this is not the original matrix. This is the document circulated this morning via email, which what it does, all the areas in the original matrix that we had asked the ministry team or legal reform or whoever to look back at or clarify or have an additional meeting, they have put all of those issues now into what I will call a new matrix that was circulated this morning, that is dated November, well, additional, it's titled Additional Research for the Joint Select Committee. So if you check your emails, team, you should see that was sent this morning. And again, the committee, the ministry apologized for just sending it this morning, but I think when we look at the breadth of work that they had to undertake to meet the timeline that we set, we appreciate that they were able to get it done. So
but
hopefully everybody.
If it's the next one, Chair, the one that I'm following, the next one speaks to the definition of access, unauthorized access to computer program or data.
Yes.
Yeah, that's what I'm trying to clarify, because I'm following the new document, but it's not matching what she's saying. So if she could just tell us what page she's on, because it's not going in that order from what I have here.
That's exactly, I'm going in the order, that is exactly the page that I'm at.
But that's page 10.
That is page 10.
Ah.
Yeah.
Yes.
It's only when
Okay,
it's
so
only when CTD Murray is only when you started out, it appeared that you were speaking of something different.
Yeah.
No. Because,
So
Okay.
if each
because
tell us the page they're on, it would help us a lot as well.
Okay.
Absolutely, no problem. So apologies for that. We
Thank
are on page 10 of the matrix, the sections 2, 1, and 3, and the matter treating with the definition of access, which involves unauthorized access to computer program or data. And what we've highlighted there is that the committee had asked us to consider the proposal by the private sector organization of Jamaica to include a provision or a framework in the legislation for ethical hackers. We had given our opinion on this, and the committee will recall that it asked us to revisit the matter, looking at standard 7 of the, well, in our revisiting of the matter to also look at standard 7 of the Data Protection Act. So I was just reminding the committee of what we would have said or shared at the sitting of the committee at which this matter was first deliberated. And we had indicated then that the act of accessing a computer system without proper authorization has existed for many years now, since the early development of information technology, and that access is considered to threaten the integrity of a computer systems, and that's by either altering or stealing, as well as the confidentiality of the computer systems by merely looking around in the computer. So criminalization of illegal access represents an important deterrent to many other subsequent acts against confidentiality, integrity, and the availability of computer systems. We noted that the Cybercrime Convention, which was used to frame our legislation, notes in relation to the various offenses that the conduct must be committed without right or without authorization. And we also indicated on that occasion that to allow access without authorization would be tantamount, in our opinion, to legitimizing access to private property. So we looked at, so there were a number of members who supported the allowing of a framework for ethical hackers to access the computer system, and we have been asked, as I indicated, to come back to you on this matter. We did our research on this issue, and what it revealed is that most countries, if not all countries, criminalize illegal access. And by that, we mean that there is the intentional accessing of computer system without authorization or the right to do so. Where there may be differences, it's in whether or not it's mere access, whether you access a computer that is not protected by security measures, whether you're accessing with a view to perpetrating some harmful intention or to obtain or modify or damage data, etc. What we note, however, is that a common component of the Cybercrime Convention, which Jamaica and other jurisdictions have used to frame their respective legislation, is that the conduct involved is done without right or without authorization. Now, the committee will recall that Lieutenant Colonel Sterling made a presentation which seeks to distinguish the types of hackers, and they were broken down into 3 types. There is the black hat hacker, the white hat, and the gray hat. And I think we all know, members, what the black hat does. The black hat hacker does his or her hacking for the purpose of stealing something valuable or other malicious reasons. And it is reasonable to assign any of 4 motivations to that, the actions or activities of a black hat hacker. That is whether it's theft, reputation, corporate espionage, and or nation state hacking. With respect to the white hacker, it was noted that these hackers strive to improve the security of an organization's security systems by finding vulnerable flaws, so that they can prevent identity theft or other cyber crimes before black hat hackers notice that there is a flaw. And of course, we know that from time to time, corporations will employ their own white hat hackers as part of their support IT staff. Then we have those that fall into the category of gray hat. And these hat hackers and gray hat hackers use their skills to break into systems and networks without permission in the same way that the black hat hackers do. But their motivation is not to, with respect to wrecking or creating criminal havoc. They might report, and I want to emphasize the word might, they might report their discovery to the target owner and offer to repair the vulnerability for a small fee. I'm going to get to distinction in a little while as when I come to the recommendation, the analysis and the recommendation. But I also now want to address the issue of the Data Protection Act, because we were asked to look specifically at standard 7 of the Data Protection Act. So members will recall that or may be aware that Section 21 of the Data Protection Act imposes a duty on data controllers to comply with the data protection standards that as articulated in the legislation. And there are 8 standards that have been articulated. And a breach of or contravention of any of the data protection standards or any provisions of Part 4 of the Act can result in a data controller being liable upon summary conviction to a fine not exceeding $2 million or imprisonment for a term not exceeding 2 years, or if conviction is on indictment, to a fine or imprisonment for a term not exceeding 7 years. Now, the specific standard that we thought we should look at in relation to this, and the committee directed us to look at, was standard 7. Now, standard 7, which is at section 30 of the Act, provides that the appropriate technical and organizational measures shall be taken by the data controller against unauthorized or unlawful processing and accidental loss or destruction of or damage to personal data. And additionally, it says that measures shall be taken to ensure that the commissioner is notified without undue delay of any breach of the data controller's security measures which affect or may affect any personal data. This section also provides guidance on the types of technical and organizational measures that can be taken and the requirements that must be met where processing is carried out by a data processor on behalf of a data controller. It is further noted that section 45 of the DPA, the Data Protection Act, places an obligation on a data controller to annually submit a data protection impact assessment outlining, among other things, the measures envisaged to address risks, including safeguards, security measures, and mechanisms to ensure the protection of personal data and to demonstrate compliance with the Act. We note that at the sitting of the committee at which this matter was initially discussed, that a reference was made to activities which would not be considered criminal if done in the public interest. But the committee is asked to note that this provision of the Data Protection Act, that is section 38 and subsection 8, is limited in nature. That section provides, my words, a defense in instances where a person willfully and without lawful authority breaches any pseudonymization or encryption applied to any personal data. So it's very specific when it is that the defense of public interest could be raised. So what subsection 8 says is that a person does not commit an offense under subsection 7 if, among other things, the breach is justifiable in the public interest. So the provisions of subsection 30, subsection 38 is therefore limited in our mind or interpretation, limited in scope, and is not of general application. So coming to the recommendations then, in light of the research findings, and we would want to ask the committee to consider the following as it contemplates whether or not there should be a regime put in place that would allow persons without authorization to access a computer system or an IT network. We draw attention to the fact that Chapter 3 of the Charter of Rights of Jamaica, of Jamaica's Constitution, provides certain rights to citizens. Those rights including protection from search of the person and property, respect for and protection of private and family life and privacy of the home, and protection of privacy of other property and of communication. Consideration therefore needs to be given to the basis on which exceptions could be made in the Cybercrimes Act to permit individuals to infringe property rights and the privacy of other property without authorization. We note that white hat hackers access networks with authorization and with contractual arrangements that outline the parameters of their engagement and provide for clear indemnification and strict confidentiality. And so what we have come to understand in respect of, and having spoken to both technical persons in the public and outside of, and in the private sector, that a white hat hacker always operates within the context of the law. And so they operate within a framework that is usually contractual in nature, where the parameters are clearly defined, where indemnification and other provisions with respect to confidentiality are articulated. So for us, what we've observed in looking at the distinction between the types of hackers is that it is the gray hat hackers who access networks without authorization and who therefore may share their discoveries and solicit a fee to repair vulnerability. With the gray hat hackers, there are no parameters or boundaries which are set in relation to access and no prior requirements to keep information access confidential. Chairman, I'm going to pause because I see a hand from Member Gale.
Senator Gale? Hold on. Are you finished, Joaquin?
No, I'm not. I'm almost.
I'm just standing in line with my hand raised.
Okay, yes. So I think allow him to come to a close.
So okay, thank you for that, Chairman. So with the gray hat hackers, there are no parameters, as I said before, or boundaries which are set in relation to how they access, and there are no prior requirements to keep information access confidential. There's also no responsibility imposed on the hacker to return data that they may have retrieved. As such, having found the vulnerability and potentially access the data, the gray hat hacker is at large to treat with the information as he or she so desires without any recourse to the network owner if such activity is decriminalized. Just two additional points. The Data Protection Act imposes an obligation on data controllers to implement technical measures to ensure the protection of personal data and to annually advise the Information Commissioner via data protection impact assessment of the measures taken to ensure the protection of personal data. Consequently, under this new data protection dispensation that we're entering into as a country, we believe that data controllers will have to be more proactive in respect to the protection of their systems. And then finally, we consulted with MOPA and the Office of the Director of Public Prosecutions on the recommendation from the PSOJ. And it was noted that to permit access without authorization would be tantamount to allowing persons to break and enter into a virtual space, which if done in the physical space is an offense. And finally, the DPP raised questions around the evidentiary challenges that could potentially arise in respect of prosecution. So questions were raised as to the evidence that would be required to establish whether an individual was acting ethically or unethically when both were done without authorization. And I stop there, Chairman and members.
What I missed, Akeem, when I looked through the matrix is you have highlighted a number of factors, areas, but is there a specific recommendation?
Oh, sorry, apologies, Chairman. Chairman, we're not supportive of introducing a regime that would allow persons to access the networks of others without the person's authorization or consent.
Understood. All right, let me take the comments now. So, Senator Gale, you first.
Yes, Chair, thank you very much. You know, I take note of the fact that the one that wears the black hat is the worst of all. And I appreciate CTD Murray, the research done in this particular area, because I recall raising this particular matter in reference to workers who may be doing research and may break into a system and would be somewhat the gray hat, but not to the extent where it is referenced just like the black hat. But instead of wreaking the criminal havoc, they might report the discovery to the owner and offer to repair at a small fee. I am at the point where they may have broken into the system, yeah, without permission, but by virtue of the skill set that they have, they can seek to promote repairing of the system, not to charge any fee. But they would not have had permission, and so we don't want to expose them to any level of criminality, yeah? Because it was never intended for the purpose of wrecking the system. And so the question of a lighter gray hat may arise if you want to use it. But that was my intention when I sought to protect these individuals who may very well utilize, have skills, have energy, doing research, and may have broken into the system without permission. It is just cause for consideration. We might not be able to fix it now, but you may come up against that situation and you don't want to expose them to criminality because it was never their intent to pursue a criminal act. And that's my concern, Chair.
Thank you, Senator Gale.
And if I might respond to Senator Gale, we understand that there are persons who, in their interaction with a network, it could be a public-facing network, that they may come across things that signal that something might be wrong. And members may recall that issue came up about what is the mechanism for persons to report if it is that they believe that there may be a flaw with a system. And we had indicated that while there is no formal arrangement outlined in any piece of legislation, that the Jamaica CERT was an avenue which could be used to say, I happen to be interfacing with this particular system, and I believe that there may be something that is wrong with it, so that the message can be delivered through a third party to the owners of the network for the necessary actions to be taken to remediate or mitigate any challenges that is identified. What we are wary of is allowing something to happen in the virtual space that in the physical space is unlawful. And I think that members have to bear that in mind. We do appreciate that the virtual space is sometimes viewed as a different space, but in our minds, something that is not lawful in the physical space ought not to be permitted in a virtual space. This is still someone's property that we would be encouraging or legitimizing, if not encouraging, legitimizing persons to actively, not in the manner that Senator Gale, you would describe it necessarily, but some could use that as a basis to actively probe persons' network, looking for breaches or vulnerabilities. And we're saying that if in this new paradigm that we're moving into with the Data Protection Act and all the requirements for compliance around technical and organizational measures to protect data, we believe that those persons who process personal data, who have IT systems and networks, are going to be required now, if they weren't before, if they didn't feel compelled to before, now required to step their game up. And we believe that they're going to actively, in this new regime, engage cybersecurity specialists, IT specialists, etc., to ensure that their systems are more secure. Bearing in mind, member colleagues, member and other committee members, that there is no system that is foolproof and that every system can potentially be hacked.
Thank you, Joaquin. Senator Cameron Rodriguez.
Thank you, Mr. Chairman. And Joaquin, thank you for that outline that you have provided. I was one of those who advocated quite vigorously for look at grey hacking as being acceptable. And sadly or otherwise, I'm still in support of that. You mentioned two bodies that the ministry conferred with on this issue. You said, can you remind me what those two entities were again?
Consulted with MOCA and the Office of the Director of Public Prosecutions.
Okay, I just wanted to be correct because that's what I have here in my notes from what you said. But isn't that consultation a little bit one-sided? In the sense, let me say, because none of those entities, nor to my knowledge, anyone in the ministry is really could be considered cybersecurity experts. And I mention this because if you're not a cybersecurity expert, the same way I yielded to Senator Longmore's professional experience, is the same way I'm thinking that we can only accept this recommendation if we also had some opinions from cybersecurity experts. I think it is important for us to have that, and especially because it was the cybersecurity experts who made this original recommendation. Because we have a few companies in Jamaica that specialize in cybersecurity and who work a lot for the government as well. And so I think it is important for us to go back to them and have that conversation so we know we're making the right decision, because right now we are not experts looking on and saying this is a bad thing. Why have a gray area and not just a black and white area if it is that we're not going to allow a little room to that gray area to do some good work? Because if a gray hatter violates gray hatting, they're a black hatter. So I think even just the definition that is on page 12 of the document we're looking at, the definitions would say to us that gray hatting is not the same as black hatting, and as such need to be considered. And I'm sorry, but if there are other persons you consulted with, you have mentioned two, And I asked again, and you mentioned the same too, if there are cybersecurity experts, especially those who made the recommendations to us in the first place, I think it's important to go back to them and have those wholesome conversations to be sure we're not just protecting something that we don't understand clearly. Because
I would say something before CTD comes in, because I think you know, in fairness, the private sector has put the question on the table, and they have made their submissions on the point for our consideration. I think one of the challenges, and this is one of the challenges that I have faced, in that while I am supportive of the concept, and I believe that there must be ways to facilitate people who have the talent and are able to do these sort of testing and providing it for the right reason in good faith. I think the difficulty is that no one has been able to put forward thus far a law that supports ethical hacking. And it was one of the questions that I had for you, Joaquin. If you had come across any law that makes this legal.
That was my second question, Chair.
So, Chair, to respond to your question, no, we haven't come across. What we have been seeing throughout the legislation supported by the Cybercrime Convention is that access without authorization is considered illegal access. And that is what we have seen. Without repeating myself too much, the fact is that the white hackers or the ethical hackers, that's because essentially those are the white hackers or white hat hackers are the ethical hackers, operate within the context of legislation, and they operate with the consent of the network owner in probing and doing penetration testing.
Yeah, that's their job.
Yeah, exactly so. And so we're saying that there is nothing that prevents a gray, potentially, hat hacker from becoming white and saying, okay, I would like to test your system, but not on their own. My words now, Chairman and members, trespass onto someone's property and then say, alas, I have found. And that is where we're having the concern, because we are constrained to draw a definition or draw a distinction, my apologies, between the virtual space and the physical space.
Continue. I don't want to stop.
Just to address Member Campbell Rodriguez's point, we did in fact consult with a private individual. I was not prepared to call names because I did not obtain the person's permission at first to single them out as supportive. But one of the things I will share without calling names from that conversation is this, that the first thing that the individual said was that anyone who doesn't operate within the context of a contract or authorization is practicing hacktivism. And I would say as well that the public sector does have cybersecurity specialists. There is one that sits in the CERT, and there are those that sit in the JCF in light of the work that they do in terms of the cyber forensic unit, as well as the MOCA. So I'm not sure, member, that it would be fair to say that the public sector does not have cybersecurity specialists. There are those also who sit in the eGov Jamaica Limited and across the public sector.
The records reflect. I never said that the public sector does not have. Please don't let the record reflect that I said that, because I did not say that. That's not what I said. I said
I do see. So just to be clear, as I'm going to go to Member Robinson, but what you are saying, CTD, is that there is already a framework for ethical hackers to engage in carrying out a process of checking systems. And that framework which is being utilized now by some private companies in relation to government, is that they engage the entity by way of a contract, or the government engages them by way of a contract, and they do that with the necessary authorization. Correct?
Yes. Yes, Chairman.
But let me ask you, Chair and Joaquin,
yeah.
What happens, how do you police where private entities engage quote unquote ethical hackers? And how do you make a distinction between a legitimate private entity like a JPS or some other, a bank, financial institution who legitimately wants to use an ethical hacker versus somebody else who uses the disguise of a contract to say he's engaging an ethical hacker, but that person really isn't an ethical hacker? Because ethical hacking is not confined to the public domain, public sector domain. So how would you treat with that? That John Brown Company Limited decides he's going to engage this person, he drafts up something saying it's ethical hacking, but it's really not.
Right. So Member Robinson, any engagement, oral or in writing, with a cybersecurity expert by a company, private or otherwise, to penetration test their network is perfectly okay. That falls outside of the ambit of the Cybercrimes Act, because that individual who is so engaged would be acting with the consent of the network, to probe the network. What we're saying is that the issue arises where there is no arrangement, and therefore no consent, no authorization, and that cybersecurity specialist then probes the network, the private or public sector network, and then finds vulnerabilities and says, oh, well, I found them, and here they are, and for a small fee, I can fix. The fact is that according to the Cybercrimes Act, that act of accessing without authorization or without right or without consent is considered criminal. So once there is permission, any at all, there is no way that that person would fall within the ambit of the legislation. Or to put another way, their actions would not be considered criminal.
So, Joaquin, what I have seen, the highest I have seen in terms of trying to facilitate, or maybe facilitate is not the word, but allowing persons unauthorized access is what is put under a terminology largely called good faith research. So I've seen some policy directives in the states that it really hasn't gone as far as legislation, but it has indicated that they would not necessarily prosecute someone who researches in good faith and brings vulnerabilities to the attention of the entity. Is it that we believe that that would be opening a can of worms if we were to?
No, member, I don't think so. I think that the conversation that we're having here with the committee, the issues that have been raised is probably something we can discuss outside of the context of this legislation, and in the way that you have positioned it, in the context of policies, so that there can be general agreement around it and support for it. Because as we said, we're concerned that there may very well be private sector persons who would not support their network being accessed without their permission, simply because someone thinks that they're doing good
research. Understood. All right, so I know this is a very topical issue. and it has detained us at the committee level for a significant amount of time. What I hear our technical team to be saying is that the law already provides for ethical hacking once done with authorization, right? But anything outside of that, they are not recommending that we take on at this time. Is the committee minded to accept the views of the technical team so that we could move to another matter? Or are there still questions, suggestions?
Here we can move on. We would have had excessive deliberations on this.
I think
there's always going to be another opportunity to get a bite at the cherry when it goes to a particular place again.
Yeah, I think as you had suggested with the other matter, I think in our report, we should highlight this specifically, right? And we should encourage the Ministry of Science, Energy and Technology to really look at policy options around the broader concept of ethical hacking, which would include those gray hatters and largely, as other jurisdictions are doing, looking at people who genuinely go out to research networks to see vulnerabilities and raise them. So I think we can use the report to incorporate that and to urge the ministry to continue the discussion. So we're not
and just to be specific in terms of the role and functioning of the possible gray hacker, one who is legitimately doing it without seeking to be incentivized.
Yeah. All right. Well, good discussion. Next matter, Joaquin.
So the next matter, Chairman, committee members, we are now on page 15, and that's treating with section 4. It was against this particular section that the Ministry of Education and Youth had recommended that harsher penalties in relation to offenses against children and be implemented or an amendment be made to the Cybercrimes Act to allow for harsher penalties. The committee is advised that we engage the Ministry of Education on the matter, and what they have recommended is that the penalties for an adult where the victim is a child be in accordance with the penalties that exist in the Child Pornography Prevention Act. The committee will note that under that piece of legislation, fines or terms, well, there are legislation speaks to generally to a fine because all the offenses in that legislation are triable in the circuit court. So there's broadly a fine that can be applied or as determined by the court, and terms of imprisonment ranging from 8 to 20 years. What we certainly noticed from our review of the legislation is that the majority of the offenses range from, in respect of terms of imprisonment, range from 15 to 20 years, and the offense which attracts a possible 8-year sentence is with respect to possession of child pornography. So that their recommendation is that the penalties be, as it relates to the term of imprisonment, range somewhere between 15 and 20 for an adult that commits an act of which the victim is a child. And that is their recommendation, Chair, committee members.
And so that's the recommendation coming from the technical team.
That's a recommendation coming from the MOEY that we're putting before the committee for consideration.
Okay, understood. Any challenges with that? The alignment?
Acceptance of that, Chair.
Yeah. All right. So unless there's any other dissenting voice, then we could move to the next section.
Right. Chairman, committee members, we had looked at section 9 already. And so we are now at page 20, section 10.1A and B. we were asked to reconsider whether the term virtual computers should be defined. This was an observation that was made by UTech, and you'll see, members, that what we found on our research is that the International Telecommunication Union, the ITU, defines, while not virtual computers, but virtual machine as a software program that simulates, my apologies, a hypothetical computer central processing unit. And we found another definition that we thought was interesting and that we would share, VMware, which is a multi-cloud service provider, defining a virtual machine as a computer resource that uses software instead of physical computer to run programs and to deploy apps. When we look at those two definitions and others that we have seen actually, we have found that, or we're still of the view that the definition that we have ascribed to computer in the Cybercrimes Act is sufficiently wide to treat with virtual computers. We know that virtual computers are really software programs that of necessity rely on a physical computer for execution. And so we think that the definition is sufficiently wide to capture virtual computers and that no further amendment is needed.
Is it that you went to the trade union and then you agreed with the trade union and come to your position?
Thank you, I'm not quite sure. But we certainly looked, not quite sure what is meant by that statement. But
it was just in guesswork. But if you say it's broad enough, it's and we take it that, you know, we take your recommendation that it's broad enough to cover virtual computers, then that's fine. That's fine with me.
Yeah, I see no challenge based on the research. Is there any other view?
And just to add, as members come in on that, Chairman, what we found too, and one of the things that we want the committee to appreciate is that this is the space is a very active space and things evolve very quickly. And we review the legislation maybe every 3 years or 4 years, and by that time, several things could have happened in the space. We want to keep the legislation as technology neutral as possible because things are evolving so quickly. So when we use terms that are being used now, we then find that 2 or 3 years later, those terms are no longer applicable because the technology has evolved. And so, I mean, I say that generally, just to say why it is that in respect of some of the definitions, the recommendations for amendment to include specific things, we have been mindful of just how active the space is.
Okay, appreciate it. Can I move to the next one?
Yes, we can, Chair. So section 10, we were asked, and this is at the bottom of page 21, we were asked to discuss with Simtai Consulting Limited the recommendation proposed by the MSET to section 10 to determine whether the proposed amendment would treat with the company's perceived ambiguity. We did speak with the representative or our representative from Simtai, shared with them the proposal that we intend to, the proposal we made to the committee in respect of section 10, and they indicated to us that they believe that the proposed amendments would adequately address the ambiguity that they had identified.
So what was the amendment?
So the amendment is on page 22 in the column analysis and recommendation. Okay. We had proposed that this section be amended to provide that an offense is committed if a person without lawful justification or intention.
Good, and you spoke back to Simtai and said they were comfortable with the amendment.
Right, we shared all of what we shared, all of what is here is what we shared with them, and they thought the proposal would
Any challenges from the committee? It's good to see
Chair.
joint select.
What was important is that, you know, the SIMTAI is in agreement with what is being proposed, since it was SIMTAI who had raised it initially.
Yeah, agreed. All right, so we're now to section 13.
Yes, Chairman, members. We were asked to dialogue with the ODPP and MOCA to understand their views on the Jamaica Bankers Association's observation regarding the burden of proof to prove innocence being placed on the accused. Just to remind members that the JBA noted that the burden of proof seems to be on the person against whom the charge is laid, and that the level of evidence required to ground an offense on this of this nature should meet the standard of criminal liability and should not shift the burden of proof on the person being accused to prove his innocence. The Attorney General's chambers had reviewed this particular issue and would have advised that it's not unusual to place a burden on an accused if there is a legal basis for doing so. And in the context, they had seen nothing that was untoward in respect of this particular provision. We were asked to discuss that matter with both the ODPP and the MOCA, and in a meeting we held with them, they both confirmed their support for the AGC's interpretation, albeit they did go a little bit further to say, well, both of them actually, yes, a little bit further to say that they didn't see a burden being imposed on the accused. What the ODPP specifically noted is that the burden is actually imposed on the Crown to disprove the matters that are outlined in subsection 3. So I suppose we can summarize it by saying, Chair Committee members, that MOCA and ODPP didn't see a cause for concern in respect of the issue that was raised by JB. And they would have agreed and more with the AGC's position or interpretation.
Okay, well, that's good. Any comments from the committee? Yeah, I think we can move forward, seeing that MOCA, Director of Public Prosecutions, our own technical team, supported the interpretation of the Attorney General's chamber. So, all right, next up would be section 60.
Section 60, yes, page 27. So we were asked to dialogue with the ODPP and MOCA to understand the comments of MOCA in relation to the section and to provide some guidance here, just for to refresh the members' memory. MOCA had asked that a mechanism be placed in the legislation that would enable law enforcement to legitimately render data inaccessible or removing that data from a device. When we met with the MOCA and the ODPP together, the ODPP had a view that there was already a mechanism within the legislation, and this would have supported the Attorney General's Chambers' conclusion that there is a mechanism in the legislation that would allow them to render inaccessible or remove data from a computer that is seized. It appears, however, that the MOCA has some further concerns. When they explained what it is that they were trying to articulate, it seemed to go a little bit deeper than what they articulated in their submission. And so what we've asked them to do is to dialogue with the ODPP on the matter and to revert to us. So committee members, this is one matter that we'll have to come back to you on, because we didn't get from the MOCA an indication that they accepted the AGC's interpretation. And as I said, I believe that's because based on how it is that they framed their initial submission, it might be that there were things that were not said that went a little deeper. And so that conversation is to happen, and MOCA is to report to the ministry on the outcomes of that conversation. And then we take it back.
Maybe in order to assist us, whatever they are contending that wasn't presented sufficiently, maybe they can provide that to us to get a clearer understanding. Absolutely,
ma'am, and that's the intention. So what we've asked them to do is to have the conversation around the broader issues with the Office of the Director of Public Prosecutions, and then come back to the ministry with their full submission and where it is that they are, so that we can take that back to the committee for consideration.
Right.
So this one, members, we don't have
section 16
conclusion on.
Understood. All right, section 18.
Okay, so with respect to section 18, the Attorney General's chambers was asked to reconsider this matter, and the AGC is on, and so I'll just defer to them at this point, Minister.
Okay. AGC.
Yes, good afternoon, Chair. When we presented on this matter, we indicated that, in our opinion, the legislation, by imposing criminal sanction for anyone who unlawfully discloses data to which they've come into possession in the execution of a warrant, to be subject to a criminal penalty means that the legislation provides protection for the confidentiality of data obtained pursuant to a warrant. A question arose regarding whether inadvertence or recklessness on the part of the person who executes the warrant would also be covered. In our opinion, the language of the provision is clear in what it requires of the person executing the warrant, so that the intention does not affect the potential liability. And in addition to that, in a situation where there is, let's say, loss to the entity or the person whose information is unlawfully disclosed, our laws do provide a mechanism for persons to seek compensation from someone who has been convicted of an offense in circumstances where it is established that the victim suffered a loss. And that provision is found in section 24A of the Criminal Justice Administration Act. So in our opinion, the existing legal framework in Jamaica, both the Cybercrimes itself, other legislation, potentially as well, the common law prohibitions on privacy, and maybe I agree with the Data Protection Act as well, all combined to address the concern regarding potential disclosure of data in the execution of a warrant.
So there will be no need for any change.
Chairman, before you close the discussion on this particular matter, if you'll indulge me a little bit, because as we looked at the outstanding matters for consideration, University of Technology also raised a similar matter, and I'm going to take so I would wish that we treat with both of them at the same time, if I'm allowed. So on page 39, they had asked a similar question. If a warrant is received for a specific offense, how should additional data found by the police on your device be treated? Take account of how this is to be done to ensure protection of data which is not the subject of the investigation. We think it's a similar issue to that which was raised by JBA, and so chairman, committee members, we believe that the response of the Attorney General's chambers, as previously given and as now articulated by Mr. Foreman, would be applicable in this case as well.
Okay.
That there is a framework for protection.
Yeah. Understood. All right, thank you. Thank you, AG Chambers. All right, where are we now, Joaquin?
Chairman, members, we are now at page 30, moving from the sectional provisions or comments on the various sections of the legislation to the more general recommendations that would have been made by stakeholders. With respect to the disclosure of a key for protected computer to an unauthorized person and unauthorized disclosure of password or access code and unlawful divulging of information, those two recommendations would have been made by the Ministry of National Security and the MOCA respectively. We were asked by the committee to seek further clarification from both entities on their proposals. What we did is that we would have shared the findings of the analysis of the Legal Reform Department in respect of both recommendations with MOCA and the MNS. What we can report to the committee on is the response, is with respect to the response from the Ministry of National Security. They have indicated that they've reviewed the recommendations and the findings of the Legal Reform Department with respect to their recommendation, and that they are guided by the LRD and would accept that guidance. We are still awaiting the response of MOCA in respect of the findings of the LRD. So while we can report or provide feedback with respect to one entity's position, we are still awaiting MOCA's response. So this is the second matter, Chairman, that we would come back to the committee on once we hear from MOCA.
MOCA, okay, no problem.
We're at page 33, Chairman, members. This is a matter with respect to phishing and social engineering. The committee had requested that further consideration be given as to determine whether other types of activities such as smishing, etc., would fall within the context of the Act, as well as the activities surrounding social engineering. We did review the Cybercrimes Act, sections 3, 5, 7, and 8, and we've outlined them there. The Law Reform Fraudulent Transactions Special Provisions Act, sections 3 and 10 in particular, and the Larceny Act, section 35, all of which are outlined in the research finding. And we would wish to reiterate our view that these pieces of legislation would, depending on the circumstances, apply to the activities that constitute the various types of phishing, as well as social engineering, as these activities, the phishing and the various types, as well as the conduct akin to social engineering, would all be preparatory activities that are generally preparatory to the commission of a fraudulent activity. So these are all steps which precede usually some fraudulent activity taking place. And so therefore, any of those three pieces of legislation would capture the activity of phishing and the various types of, as well as social engineering.
Okay, so you believe we're adequately covered in relation to?
That is our view.
Okay. Any question from the committee? If not, I think we will go to page 38.
Yes, Chairman. This particular matter was just to refer recommendations from the Office of the Director of Public Prosecutions in respect of the amending the Fingerprints Act. We shared the recommendation with the Ministry of National Security, who has portfolio responsibility for that legislation. And they advised us that that cognizance was taken of the ODPP's recommendation at the time they made their initial presentation, and that the recommendation is being considered by their law enforcement policy unit for inclusion in the current review Fingerprints Act.
Okay, but that is really in relation to the Fingerprints Act.
Yes.
Okay. All right, I think we're still on 38.
It's still on 38 on to 39. So There was a recommendation from the committee that a written explanation be sent to all the entities that made recommendations to the committee, especially those entities which raised concerns about the provisions of the Act, which are actually covered by Section 4. And it was also suggested that an explanatory note on the provisions of the Act be done. We note the recommendation, and we note that there is an activity with which the ministry will have to engage in relation to public education and awareness around the provisions of the legislation and how they are to be interpreted. But we would want to recommend to the committee for consideration that the report of the committee, once approved by Parliament, that be shared with all persons and entities or which would have made submissions to the committee. We believe that if the report is shared, then this will afford each entity the opportunity to assess the committee's treatment of their respective recommendations, provide a fulsome picture of the committee's deliberation on all the recommendations or submissions, and provide an overarching view to all the submitters of the proposed amendments that the committee would be making, or recommending rather, be made to the legislation. So we would wish committee chair and committee members that the report be the basis of what is circulated as the ministry undertakes its broad public education awareness campaign around provisions of the legislation.
Chairman, I like that approach. I don't know if it has ever been done before, but if there are interested parties that came to a joint select committee and made recommendations, then the full report to be presented to them, I think it's a good way going forward. And I would also recommend that other joint select committees promote that kind of concept.
Yeah, I agree 100% again. I think it should be standard, and I agree, CTD, that's a better approach, that we present the report, share the report once it has been tabled with all the persons who made submissions, so they can see that it was not in vain.
Yeah, you see, writing to a select group or a singular group, it is not so specific, other than, you know, you're writing to everybody, so everybody sees what everybody gets.
Yes.
Or everyone else receives.
Okay. Yeah, appreciate it. All right, I think we're almost there.
Almost at the end.
Yes.
Yes.
So I would just love us to finish these. I think
absolutely.
So,
yes.
Yes.
So we're almost there, Chairman, members. So we're jumping to page 42, Financial Services Commission extradition, because we've already dealt with that other matter from UTEC in the discussion with AGC. So here, the query from the Financial Services Commission was whether, well, they noted that there was no reference to extradition of our nationals if overseas authorities trace illegal activities to Jamaican nationals. And that is correct. There is no provision in the cybercrimes legislation for in respect of or relating to extradition. But that's because we do have an Extradition Act, which outlines the basis on which extradition will take place. And we note, and we've set out the section there for the members to look at if they so desire, but in the main, what is required is that, well, section 5.1 says that any offense of which a person is accused or has been convicted in an approved state, and the Act defines or what an approved state is an extradition offense if, in the case of an offense against the law of a designated Commonwealth state, it is an offense which is punishable under the law with imprisonment for a term for 2 years. In other words, in both in that particular state and in our state, the offense is an offense, and that treats with the whole issue of double or dual criminality, and that the term of imprisonment is in excess of 2 years. Then in that instance, and then it goes on to say that the act or omission constituting the offense would constitute an offense in Jamaica, double criminality element. In those instances, there can be extradition.
Yeah.
So it is
Extradition
treated.
Act already covers
Correct.
it.
Right. So we don't need specific reference in the Cybercrimes Act in respect of extradition.
Okay.
And then the two final matters, Chairman, committee members, I'll take as one because they are similar. MOCA had recommended that it should be mandatory that all wireless networks be protected, and as a mitigating measure for eavesdropping, networked information leaking, and criminals arbitrarily using open networks to commit cybercrimes. And UTEC also made the observation that we have to give consideration to persons connecting to another's open Wi-Fi when there is no clear declaration that such action is unauthorized. And also noted that knowingly providing an open Wi-Fi with an intent to commit an act of extracting or altering the person's data or tricking the person to commit an offense is something that would need to be addressed, or an offense should be created in respect of this. We understand both entities to be saying that there really needs to be an offense created where that would, one, mandate persons to protect their Wi-Fi, and also that where you are using an open Wi-Fi and data is extracted or altered, etc., then that should be an offense. And wanted to look at it from both the policy side as well as the legislative side. In respect of MOCA's recommendation, we want to point out that the government of Jamaica's policy, ICT policy, is anchored in 4 fundamental principles, one of which is universal service. And the policy articulates that the government will promote affordable and accessible high-capacity networks and facilities island-wide. And among the strategies identified in the policy, and one that we're actively as the government, and it's through its entities implementing, is the utilization of the Universal Service Fund to support connectivity across the island. So I think members on the call and everyone is aware of the work that the Universal Service Fund has been doing to establish public Wi-Fi and community Wi-Fi hotspots island-wide. I've given some figures there, chairman, committee members, of how many have been established, 19 in major towns, and of course the work that the USF is doing along with members of parliament in respect of establishing community Wi-Fi in their constituencies. To date, 171 have been established, with the intention to complete 18 by the end of November. And so what we're saying, committee chairman, committee members, is this: that in light of the GOJ's stated policy objective to enable access to the internet by the populace through, among other things, the Wi-Fi facilities, we couldn't support MOCA's recommendation, even though we understand it. We can't support making it mandatory that wireless networks be password protected, etc., because that would defeat the objective of allowing for access generally and broadly, and will certainly run contrary to the work that is being done by the Universal Service Fund. We are mindful of the inherent cybersecurity and data protection issues, and we believe that an active public education and awareness campaign is what is required. And we might just add that we know that Universal Service Fund, as it rolls out its public Wi-Fi and community Wi-Fi hotspots, continues to deliver the message of being safe. And so that, chairman, members, is our response in respect of the recommendation with respect to mandatory protection of wireless networks.
Any comments on this point?
Sharon, you're not going to have like everything possible. So you encourage persons who have businesses or private Wi-Fi to protect them. But where you have it in a public space where we are promoting access, then I don't believe it's possible. And I want to use the opportunity to commend the Universal Service Fund for the extent to which it has provided access to Wi-Fi in public spaces. But I don't believe we can get to the stage where, we're going to have to be able to protect, especially in the public space.
No, I think CTD hit the nail on the head. Clearly, what we have to ensure is that we have a significant public education drive in relation to potential risk of using open Wi-Fi systems. It's just something that everybody has to be aware of, but definitely in relation to access, I agree with the policy position of the Ministry of Science, Energy and Technology. And I join with you, Senator Gale. I think all of us as MPs will join with you in relation to the work that is happening right across Jamaica to bring Wi-Fi into multiple areas. And I'm telling you, it's having a tremendous, tremendous impact. And, I'll share a story that in one of my communities, we brought it into a small, not even a square, right? But very well populated. And I went down there a few weeks ago and I realized that the shop in the square had now put on the outside a new sign that said Wi-Fi here. So they're using it as a tool.
Customers.
Wi-Fi available here. But it's amazing. It's amazing.
That's the ingenuity.
Absolutely.
Of our people.
To the minister, absolutely. All right. Well, I think we are finished, right, Joaquin? I mean, outside of the areas that we have already identified that we are to come back for. We have gone through now all the other comments.
So there are the two ones, Chairman, that we're to hear back from MOCA in respect of, and there is one that we are still doing the research around, and that is in respect of a recommendation from the UTEC, I believe it's UTEC, around legislative sandbox. We're still researching that. So it's 3 matters that we would be coming back with. And so,
yes,
and then
I remember that one.
Right. So we're still doing some work on that, and we would be coming that with, and that would be it for the committee would have.
Well, good. I think we've been very productive, and again, I started by commending the team, and I'm sure all the members of the committee want to commend you, CTD, and the full team, legal reform, the AGC, the Houses of Parliament team, for sticking to the time frame, completing the work, and being able to walk us through it in such clear terms. Do we have another date, Chazan? Is that already set? The date for the next meeting?
No, Chair. The proposed date that we're looking at is Wednesday, December the 14th at 2 p.m.
Yes, I think that is good. I think all of us would want to complete this work before the end of the year. I don't think we want to bring it into the new year. So is that date okay with the team?
Sorry, Chair, you should ask the technical team if they are able to respond by that time with all the research of these areas that continues to elude us.
They're just waiting on MOCA now, and they have
yes, that's just one matter.
Yeah,
we will be ready, and we'll be ready, and we understand the imperative. We want to support the objective of the committee.
Yeah, we don't want to carry this into the new year, and I'm sure Parliament doesn't want to have this committee to have to schedule in the new year. They're really overburdened. So December 14th at what time, Ms. Brandon?
2 p.m. Chair.
At 2 p.m. So that's Wednesday, December 14th at 2 p.m. That would be our next meeting. And
Chairman, Senator Longmore, through you, just if we have time still, if we can still reflect on that matter, I would appreciate such.
No problem. So in other words, CTD and team that has already been researching the mental health matter, don't close the research just yet. If there are any new perspectives that you can share you would have heard the discussion that the committee had and the views of the committee. So if there are any perspectives that can help us to get closer to where we want to be, come with them on the 14th of December. All right.
Noted, Chairman.
Okay, so is there any other business? We'll set the date of the next meeting. So if not, who shall ask for the adjournment?
I so move, Chair.
I knew it would be you, Kavan, and I think it's seconded.
Seconded.
Thank you, everybody. Enjoy the rest of the day. And I know people like Kavan, who consider themselves Brazilians, are in the
I am elated.
best of moods. Jamaica will be a happy place this evening.
Yes.
Well, when sweet daddy goat might run the belly, so don't get too excited. All right, everybody, enjoy the rest of the day.
Everyone.